Good morning and welcome to our jurisprudence class. So this morning we want to have a discussion of our first substantive topic within the framework of our course outline for the semester. So we are going to look at very important introductory matter, the nature of jurisprudence or introduction to jurisprudence. And for this lecture, I am basing myself on the core material, Curzon's Jurisprudence Lectures, Chapter 1, published by the Cavendish publishers. I have already shared a PDF version of the book itself with you, just in case you don't have the hard copy. So we would like to explore pertinent issue as what is jurisprudence? Why is it difficult to define jurisprudence? And despite the difficulties, can we attempt some definition? What are some of the key concepts, the key ideas, which we need to be familiar with at the very outset? So these are some of the matters which we are interested in exploring in this first lecture before we start discussing the schools. So, what is jurisprudence? What are its methods and concepts, and why it matters? That is the focus of our exploration today. So we begin with what is jurisprudence? And it is quite typical in every knowledge field to want to have some definition of what you are doing, and definition is important, but it is also true that jurisprudence is notoriously hard to define. It's hard to define not only because it's jurisprudence, but because the task of providing definition for anything in itself is very difficult. Indeed, when you are trying to define something, that is an attempt to state with an acceptable degree of precision or specificity the set features or properties possessed by the phenomenon or the particular thing being defined. That is, you want to identify essential qualities, essential features of that which is being defined, so that if those essential features are seen, we can say that it is that thing which you are trying to define. And that is difficult. The reason being that you may sometimes overstate the essential qualities so that you end up losing the essence of the definition and just simply say that almost everything is part of what you are trying to define. And that would let us lose the point of even providing definition. Because if the point of providing definition is to provide delineation, that is, to demarcate the boundaries of the thing being defined so that we know what is within and what is outside, then it is important not to overstate it. Again, it is also likely that you may, in your effort to avoid overstating it, you may also understate the essential qualities of what is being defined, so that uh, certain things which ought to have formed part of the scope may be left out. So those are some of the challenges. Now, despite these practical problems in trying to provide definition for anything, uh, scholars, including Curzon, will break the point for us that the difficulty is not a reason to abandon the enterprise of trying to provide definition for jurisprudence. Rather, it shows why we must work with tentative definition. Some provisional definition for purposes of having a structured approach to learning or the exploration, as the definition will delineate the content, that is, define or demarcate the content, what forms part of it and what does not form part of it, expose families of related problems, and mark out the boundaries of the subject, so that when we say we are doing jurisprudence, we are quite clear what we are talking about. No wonder, in the course of our studies, you come across scholars like John Austin, who will go to the extent of giving a title to his magnum opus, his great work, and you call it The Province of Jurisprudence Determined. So that is the title of his work, The Province of Jurisprudence Determined. The original work is there. I think I have the PDF version somewhere if you're interested. When we get to legal positivism, I'll share it with you. But I'm just interested in the title, The Province of Jurisprudence Determined, which presupposes that there's a need to draw the boundary, to delineate what really constitutes part of jurisprudence and what does not. And that is exactly what we are being told should motivate us not to abandon the quest for trying to have some kind of definition of jurisprudence, despite the obvious practical challenges we have earlier alluded to. In that respect, we need to apprise ourselves of some of the computing formulations of definition. Those who have attempted to provide some definition of this particular subject. We need to be familiar with some of them. For example, Alan will say that jurisprudence is the scientific synthesis of the law's essential principles. And Ulpian, another scholar, Ulpian, will say that the knowledge of things divine and human, the knowledge of the just and unjust. So for him, jurisprudence is the knowledge of things divine and human, and then the knowledge of the just and unjust. And another scholar, if you take Cross, for example, Cross will say that jurisprudence is the study of a lawyer's fundamental assumptions. The study of a lawyer's fundamental assumptions. And again, Jolowicz will tell us that jurisprudence is a general theoretical discussion about law and its principles, as opposed to the study of actual rules of law. Similarly, Stone will tell us that jurisprudence is a lawyer's examination of the precepts, ideals, and techniques of the law in the light derived from present knowledge in disciplines other than the law. And Llewellyn will tell us that jurisprudence means, to me, any careful and sustained thinking about any phase of things legal. If the thinking seems to reach beyond the practical solution of an immediate problem in hand. So jurisprudence thus includes any type at all of honest and thoughtful generalization in the field of legal. So that is how Llewellyn also defined jurisprudence. So these various attempts or formulations of what jurisprudence is certainly bring up different emphasis, different perspective. So knowledge of the just. So telling us scientific jurisprudence about knowing what is just, telling us that it is scientific synthesis, abstract investigation, theoretical discussion beyond rules, interdisciplinary reflection, and systematic legal reasoning. So all these ideas come up from the various classical formulations of what jurisprudence is. Well, just to have a working compass for purposes of our course, it suffices to say that jurisprudence is a conceptual, normative, and empirical study of law, its concepts, its justification, and its operation, which is distinct from but continuous with doctrinal analysis. Good. So we come back to the problem of definition and why it matters. So what makes defining jurisprudence difficult? What makes it difficult? We have subjectivity problem. Subjectivity problem in the sense that there are a lot of terms in this knowledge field which are value-laden, which are highly subjective. Highly subjective. What are these terms? Justice, rights, duties. For example, in Ghana, we have our national motto, freedom and what? Justice. What is the meaning of the justice in the freedom and justice? Again, our courts are called courts of justice, and judges take the judicial oath to administer justice without fear or favor, ill will or affection. So what is justice? When we say rights, it's highly subjective. If you have a right, does it mean someone has a corresponding obligation to perform a duty so that you can enjoy that right? Or what? So rights as in human rights, right as in other forms of legal relation, even outside human rights. What is it? Duties. When we say duties, what are they? Now, each of these terms are highly subjective. Their meaning could be influenced by whoever is trying to explain it. And he or she may explain it according to his own biases or his own worldview or his own understanding of things. So those are some of the things we are talking about. And that certainly add to the difficulty in trying to define jurisprudence. We have other disciplines, such as economics, for example, where we have certain terms that are subjective, but we're able to define economics. For example, when you say utility, those of you who've done economics before, if you do the theory of consumer behavior, when we say utility, that is the satisfaction which a consumer is supposed to derive from consumption of a good or a service. Utility, for example, is highly subjective because uh, what will give or the value in terms of usefulness, satisfaction, which you derive from something, will vary from one person to another. But that's notwithstanding, uh, economics has got some generally reasonable and acceptable definition. In the same way, when we come to psychology, we also have the problem of subjectivity, and yet uh, psychology is reasonably defined. So, for example, rational expectation. When you say rational expectation, what is it? It's also subjective, but that has not prevented us from being able to draw the boundaries of what constitutes psychology. Now, in jurisprudence, we are still confronted with the problem of shifting meanings. The meanings or legal concepts evolve. So, for example, if you take the offense of theft or stealing, for example, if you are talking with respect to English law, the Theft Act, for example, we have had various cases in which the meaning of appropriation has been explained differently. And you know, dishonest appropriation is a requirement for stealing or theft. But how that has been interpreted has been shifting. So therefore, the context becomes very important. So the meaning of some of these concepts in certain areas of the law are context sensitive. Context sensitive. So that is one thing we should be conscious of. And we should also be very modest or humble in trying to prescribe what are the essential qualities of a particular thing. What is the essence of something? And that modesty is necessitated by what we have just experienced, that meanings of things keep evolving in the law. Now, another difficulty is that there's what we call the lack of shared norms. We have theoretical disagreement over values. In other words, what really matters that should enable us to use as a benchmark or reference point in deciding whether something is good or something is bad. We don't necessarily have shared values or consensus. So, if you take Karl Marx, what Karl Marx will, for example, consider as freedom is different from what J.S. Mills, one of the social contrarians, will explain as a freedom. So, Karl Marx, freedom, among other things, will be liberation of the masses, the, the proletariat from the dominance of the bourgeoisie or the small elite. Now, when the masses are so liberated, then there's a freedom. But Mills would probably say different. And because of the disagreement over values, it makes it difficult to have a one-size-fits-all definition. Like to have a definition which will be appropriate for all is very elusive. Again, we have methodological objections. We have objections as to the approaches or the methodology which should be used in even trying to define. So, the Bentham will, for example, bring up the point that definitions per genus et differentiam do no real work for abstract legal terms. In other words, is reminding us that if your method of trying to define is to try and get the genus, like the particular family out of which things belong, then you would actually run into a dead end, a difficulty, because legal terms are often abstract and they are not amenable to such way or such method of trying to define things. In the same way, the learned scholar Karl Popper also reminds us that the value of definitions is generally low, that we should not place too much premium on definition. Now, we are now aware of how difficult it is to define jurisprudence. So we ask ourselves, are definitions still important? Will definition still help? Certainly, yes. Definitions are frames that make inquiry tractable, understandable. So the frame can be as important as a picture. So just imagine you have yesterday, your seniors were called to the bar, they became lawyers. I look forward to also, seeing all of you at the bar in 2 years' time or 3 years' time. Okay, we're going to finish next year. Now, they will take pictures. You put the pictures in the frame, and the beauty of the picture is enhanced or facilitated by the frame as well, isn't it? So, in the same vein, definitions are frames that make inquiry tractable, understandable, or appreciable. So they prevent what Allen calls megalomaniac jurisprudence, a discipline that claims everything and explains nothing, or what we say that he is a jacks of all trade, master of none. So that if you try to have a definition of jurisprudence, you avoid the situation of having the subject become what Allen calls a megalomaniac jurisprudence. That is a discipline that claims everything and explains nothing. We want to avoid that. And for that matter, a tentative definition is a tabula in naufragio. That is a lifeline that organizes inquiry while staying revisable in the light of arguments and evidence. So we have a working definition, but the working definition is not actually fixed. Well, we are not fixated with the definition we have. We are open to adapting it and tweaking it as we get a better and better argument of what things are and then the evidence. So we are open to refining the definition, but that does not mean that we shouldn't have some provisional definition to be guiding us. And that is why it's so important to define jurisprudence. So then, jurisprudence interact with three doctrine through three complementary modes. What are these? So we first talk about conceptual inquiry or analytical inquiry. So conceptual or analytical inquiry clarifies the use and function of legal concepts rather than chasing metaphysical essence. So instead of trying to get a very esoteric or strange house-sounding ideas of what really counts in order for something to, for example, be part of what we are talking about as jurisprudence, the conceptual or the analytical approach is not interested in that. It is interested in we trying to provide clarity, proper explanation of the use and functions of legal concepts. And that is why Professor Hart will provide advice or counsel in his important work, The Concept of Law, which you'll be reading when we are discussing legal positivism. Professor Hart would replace what is X with under what condition does the law ascribe S. So instead of saying that what is X, Hart will say that that is not important because you run into the difficulty of chasing metaphysical essence, abstraction. So rather, why not be interested in under what conditions does the law ascribe S? For example, under what condition does the law ascribe corporate liability? So, instead of trying to define the rare essence of corporate liability, let's find out when would the law say that this should give rise to corporate liability and not, if you like, a personal liability in the transaction, as it were. Or even later on, when we are doing company law, lifting the veil. Under what conditions would the law pierce or lift the corporate veil? Again, in talking about conceptual or analytical inquiry, we also have linguistic approach or linguistic philosophy. So scholars like with genus and Carnap will remind us that meaning is tied to use. The same string of words can serve descriptive or emotive motion functions. The same words. And so the point they're trying to tell us is that the meaning of a word is very much linked to how it is used. And that is why the same string of words, it can provide very good description. And in another breath, it can also be emotive, provoke certain emotional reactions. Now we also have normative philosophical inquiry. And it asks questions about legitimacy, obligation, and the good. So what is legitimate? What makes obligation? And what is good? So these are matters which are probed by normative philosophical inquiry. So therefore, jurisprudence is the philosophy of law. So it's a philosophy of law in the sense that it asks questions about what makes the law legitimate. What is the basis of imposing obligation? And what is good? So typical outputs or outcome of normative inquiry will be having reasons, for example, for or against criminalization. So when it comes to assisted dying, for example, or suicide, in our law, it used to be an offense to attempt it. If you attempted and you're not successful, you had committed a crime and you were to be punished if found guilty. Now, not too long ago, our lawmakers, aided by emerging understanding that those who make such attempts and those who succeed, they are often uh, overwhelmed by certain experiences, for which reason they may be led to undertake such actions to end their lives. And if they don't succeed, society should be more sympathetic and provide support than trying to punish them. So it has been decriminalized. It's no longer like a crime. Now, again, when it comes to sanctity of life, that life is sacred, it has also informed criminalization and decriminalization of certain things. For example, abortion. Again, models of the rule of law. What count as rule of law? Normative inquiry will help us to get that. So when it comes to things like constitutionalism too, you'll be told that it's not enough just to have a constitution and say that a country or jurisdiction is practicing constitutionalism. More importantly, it should be accompanied by the conviction, the ethos among the governors and the governed that there's a need to impose limitations on the powers of governors or those who govern. So once that ethos, that conviction is there, then you can have proper constitutionalism, not just what the books say. Again, accounts of authority as to whether someone has authority or not, authority is properly exercised or not. All those are matters whose normative inquiry will concern itself with. We also have empirical inquiry. Empirical inquiry. So here we are interested in sociolegal inquiry and realist inquiry. And this empirical mode of jurisprudence, what does it do? It attempts to explain what legal institutions do, not just what rules say. So it's not concerned about just what the law is saying, but more importantly, what legal institutions do. So the empirical approach in jurisprudence, like reflected typically in the sociological approaches like sociological jurisprudence and then legal realism, they are not interested in just understanding what the law say about legal institutions, but more importantly, what legal institutions do. So in the course of our learning of this course, as we learn American legal realism, we come across scholars like Oliver Wendell Holmes in his famous The Bad Man Theory of Law. He will talk about what we call the prediction thesis. And the prediction thesis will say that the bad man does not care about what the law is, but what he cares about is what will be his punishment or what will be the consequence of the law if he is in breach or if he violates it. And that is the concern of the bad man. So, in Holmes' predictions thesis, you say that law, as I look at it, is found in the cause behavior. So he's saying that if you want to understand law, if you want to know law, it's not just reading the law in the books, but looking at the behavior of the courts in relation to the rules. So therefore, we say that as I look at it, law is found in the cause behavior. Reducing cases to rules is already jurisprudence. So for him, if you begin to pay attention to judicial decisions, then in his view, you're already doing jurisprudence. We also have scholars like Dannett and Jackson who look at legal discourse and semiotics. I mean, from the point of view of linguistics, and will tell us that legal language is a tool for negotiating social order. So, a tool for negotiating social order. And for that matter, meaning depends on institutional practices and science. So from those who approach this field from language analysis, legal discourse and semiotics, they're saying that yes, legal language is a tool for negotiating social order. So therefore, we have the law on various things, and ultimately what they are supposed to do is to ensure order. And that is why they are saying that it's a tool for negotiating social order. And for that matter, meaning of the law depends on institutional practices and science. So if you want to understand the law on anything, it's important in their view to look at what various institutions related to the law actually do and the necessary science. So therefore, in hard cases, that is, in cases which are not very straightforward because we do not have any particular precedent, for example, speaking to it, we typically need conceptual clarity, normative justification, and an empirical sense of how institution will actually respond. So you see how all the three modes of inquiry in jurisprudence could be important in one way or the other. So let us pay attention to some focus concepts in this area. So we first of all talk about the validity and morality, what we call the separability thesis or separability question. And very soon, you will notice that there are two major schools of jurisprudence, and they are giving rise to some others. But the major schools are really two: the natural law school and legal positivism. And the natural law school and legal positivism, the natural law tells us that law is a reflection of certain higher moralities, which are universal, unchangeable, eternally valid, and so on. So therefore, law is not just what it is, but importantly, for them, as whether the law is good or bad, whether the law is just or not just. So that is what is important. And then we also have legal positivism, and we will come to know later on that the legal positivists are not interested in whether the law is just or not just, good or bad, but they are interested in what the law is. Who has authority to give the law? Has the law come from the source where law is supposed to come from? If it is, then it does not matter whether it is just or not just. That is the law. So that is a legal positivist. And because of that, there is what we call the is ought question. Is stroke ought. So the is refers to legal positivism, and then the ought refers to natural law, if you like. So, and the legal positivists will talk about separability thesis, the fact that what the law ought to be should be separated from what the law is. Or what the law is should be separated from what the law ought to be. And for them, the focus of jurisprudence should be on the is question, not the ought question. That is what the law is. So validity concerns a rule's sources and pedigree. The source of the legal rules. Where do they come from? Their origin. So their sources and pedigree within the system. Whereas morality concerns itself with justification. Now, later on, we come to know that Professor Hart defends a conceptual separability, defends the position that what the law is should be separated from what the law ought to be. So legal validity does not conceptually depend on moral merit. In other words, what the law is, what is the law in his view, should not depend upon the morality of the law. Conversely, moral appraisal is not reducible to validity. In other words, as we try to interrogate the law, we find out whether it is morally good or bad, just or unjust, should not become the basis of determining whether the law is valid or not valid. So that is the essence or the focus of what they call the separability thesis or separability question. So later on, we come across one respected natural law scholar called Longfuller. Now, Professor Longfuller will reply Professor Hart's separability thesis and says that legality has an inner morality. In other words, in talking about what the law is, in terms of whether it came from the right sources and pedigree within the system, in Longfuller's view, there is inbuilt morality in that. And what is that? So he will tell us that how the law even is. Does it provide general principles for allowing application and adaptation to specific situations? Is the law giving the requisite publicity so that those who are supposed to be governed by it will be aware of it? Because how can you have your actions or life to be governed by law if you are not aware of it? Just imagine you are arrested by the police or someone sues you in the law court, and you are being told that certain actions you indulge in or certain omissions you indulge in have violated the law. And for that matter, you are going to be slapped with certain sanctions or consequences. When, as a matter of fact, you did not know about the law, or there's no even constructive means by which you could be fixed with knowledge of the law. Now, will that be appropriate? And that is why Fuller will tell us that, yes, even if it is your view that the law is that which came from appropriate source and has the appropriate pedigree within the system, we must ensure that it will be given the requisite publication. So therefore, if you look at our Article 106 of the 1992 Constitution, when it comes to making of laws, one of the things which we are supposed to do is that it should be gazetted. It should be gazetted. If you go to Article 11, Clause 7, if you where delegated legislations are made, they are supposed to be gazetted. And when information is put in the gazette, the legal presumption is that it's communicated to all, the whole country. So assuming we didn't have anything like that, and somebody who is supposed to make the law will just make the law and say that I've made the law, but there's no a common place where we can go to find out whether there's a new law. That will actually be very difficult. But now, at least if you consult the Gazette, you know what new laws have been made, and so on and so forth. So, Fuller's view is that legality has an inner morality entwined or inextricably linked with validity in practice. And that is why in various cases, the Supreme Court has had the occasion to actually strike down, for example, certain CI, which the Electoral Commission did, because it did not, for example, satisfy the 21 sitting parliament days, as enjoined by Article 11, Clause 7, among other things. Yes, the Electoral Commission and Parliament, they are supposed to make those rules as it were, but then there is also a requirement, some procedural requirement, and if they are not satisfied, it affects validity. And that is the point Fuller is telling us, that there is inner morality which is intertwined with the validity in practice. So the takeaway from our discourse so far is to distinguish identifying law from appraising it or evaluating it. So identifying law, that is trying to find out what the law is a separate exercise from appraising or evaluating whether the law is good or not good, whether the law is just or not just. But we must not have insularity perspective. We have to remain alert to points of contact. We have to appreciate that even in attempting to identify the law, as Fuller has brought up, there will be some inner morality in a sense. But we come and talk about this as we take substantive areas of jurisprudence. Yes, Kutu Echampong. Yeah, Kutu Echampong, you can speak. Your hand was up.
I'm sorry, my lord, it was a mistake.
All right.
Thank you.
Another point worth noting at the very introductory stage of jurisprudence is what we call reasons for action, including exclusionary reasons. So Joseph Raz will tell us that law supplies practical reasons, and often they are exclusionary. That is, enable us to take other situations out and displacing some first order reasons. So therefore, understanding law's normativity. Now, when I say law's normativity now, we understand it. We are talking about the, if you like, the morality of the law. Understanding the law's normativity requires both institutional sources and practical reason structure. So, in that respect, we need to appreciate what Professor Hart calls the internal point of view. We'll come and discuss that when we are talking about Hart's approach to legal positivism. But Hart, in his work, will tell us that social rules are not mere habits. So they are not mere habits, social rules which would actually give rise to what we call law. They are not just a mere habit. And officials and often citizens adopt what he calls an internal point of view. We will illustrate. That is, they treat rules as standards that ought to guide conduct and provide reasons for criticism. I'll give you an example. So, if you take driving, it is a requirement that if you are to drive, you must have driver's license. So the rule that you must have driver's license will let everyone who sits behind the steer become concerned as whether he has obtained the license or not. And if you take, for example, law enforcement officers like the MTT or the police, they would be using the requirement of you having license as a reference point to determine who should be allowed to drive and who should be prevented. So if you have run into someone's car or you've knocked something down, first point of inquiry will be your license. Before we even come to talk about you not driving properly and so on. If you do not have license, that is a legitimate basis for criticizing your conduct for driving without license before we even come to assess whether you drove properly or you did not drive properly. So, in Hart's view, citizens, drivers, as well as law enforcement officers, using the illustration that I just provided, will treat the rules as standards that ought to guide conduct and provide reasons for what? For criticism. And in his view, this explains the difference between being obliged, that is coercion, and having an obligation, a normative stance, and underpins the idea of a legal system rather than convergent behavior. So, he will say that law is not a gunman's at writ large. In other words, no, somebody holds a gun to your head and say that bring the money or do this or do that, otherwise I will shoot you. He said the law is not really like that. Of course, later on, we come and talk about what we call the command theory of law and he was trying to criticize those who try to reduce law to being command backed by sanctions and so on, and saying that law is not just like that. And law is actually about people having a sense of obligation that certain things should be done or certain things should not be done. So let's say a few words about conceptual analysis and genealogy. So conceptual analysis and jurisprudence clarifies how we use terms. So for example, there's a topic what we call uh, analysis of right, and we're talking about Hofeldian analysis. This scholar Wesley Newcombe Hofeld, he did a work and took the view that legal concepts are used indiscriminately, and the indiscriminate use is worsened by the fact that words are largely chameleon hued. You know, chameleon, the chameleon changes its color according to the color of the environment in which it finds itself. And because a lot of words have that tendency, we have that elasticity and that variability. So, such behavior affects our proper understanding of their proper usage. And that is why he will take even the word rights, okay? And he'll say that when we say rights, right is used, in many ways. You have the right to education. He has a right, somebody will say that, yes, the officer has the right to punish you. The officer has a right not to give you a request. Or this person has a right not to be denied that position. Now, if you look at these sentences in which the word right is used, if you pay closer attention to them, you will notice that they cannot all be meaning the same thing as far as the right is concerned. And there are different senses. So, if that is the case, which of the various uses should be accepted as a proper meaning or understanding of right for proper legal discourse? And that is why I know he will try and do his nice scheme. We'll discuss that in the second semester. So it's example of conceptual analysis. In the same vein, we come across even John Austin, Jeremy Bentham. Most of the analytical jurisprudence, they will take the view that we need to break down words so that we're able to isolate exactly the aspect which reflects the meaning that we are after. So we also have genealogy, like Michel Foucault, that great French scholar. And genealogy traces how our categories were historically produced by power or knowledge formations. So it is explanatory rather than classificatory. So especially those who will talk about how there has been power relations in society, and that power relations have actually influenced how a lot of things, are in society. So it's an attempt to try and explain phenomena rather than to try and provide any classification, as it were, for us. So if you use conceptual analysis and genealogy, you avoid verification. That is to say that we can speak precisely about our concepts while remaining open to historical contingencies that produce them. So there are a lot of things. For example, when it comes to um, head of family accountability, okay, those who did the law school entrance examination, there was a land law question regarding managers of school land and family lands, and then the legal accountability framework for them. Very straightforward questions for 25 marks. So if we take head of family accountability, school accountability, and all that, if we look at our customary law, right, the cases that are actually discussed in our customary law, you will notice that for a long time, it was the customary law position that a member could not even hold the head of family to give an account. But later on, the case law started evolving, trying to give situations in which through the entire family, the head of family may be brought to accountability. And that was even not enough. It has to take the enactment of the PNDC law, head of family accountability law. And that also even did not extend to those in charge of schools and screen lands. And then it will be later on that there will be an extension, including the New Land Act of 2020 and a provision in the directive principles of state policy. So here we see how historical happenings also shape how a particular concept or particular principle have evolved. So let's explore briefly language, context, and mobility of legal meaning. The fact that legal meaning is not static and it's always shifting. So legal terms, as we have appreciated by now, lack fixed essence. That is to say that we do not have a fixed core meaning. And meaning depends on context and institutional use. So that is one thing that we should keep in mind. You take so many words. The possession. Possession, you know how it has a various meaning. In land law, tort, criminal law. Then, if you take appropriation, in theft law or stealing, the case of Morris, suggested that assuming any right of the owner can constitute what? Appropriation. That if you purport to exercise a right in relation to the particular thing which an owner will do, that suffices as what? As appropriation. But Aaron Gomez will tell us that even with the owner's ostensible consent obtained by deception, there may be appropriation. So if the owner has given consent, but the consent was obtained because we deceived the owner, that will still suffice as appropriation. And the fact that consent was given will be immaterial or inconsequential. Again, if we look at R and Gosh with respect to dishonesty, a two-stage test which combines ordinary standard with defendant awareness is actually adopted. But later on, the case law will refine and say that it is important to focus on objective standard in trying to find out whether there has been dishonesty and rather remove the defendant's awareness. So it's not the subjective thinking which matters, but objectively, whether we can say that there has been dishonesty. So Curzon has cited these examples to drive home the point that jurisprudence must reckon with semantic drift. Semantic drift means that shifting meanings, that meaning is not static, while staying attentive to how courts stabilize meaning through practice. So let's keep that in mind. And of course, this will come back to what Oliver Holmes is telling us, that to understand the law, we have to look at judicial behavior. You have to look at case law. So if you are a student and, for example, you don't like reading cases, what it means is that your understanding of the law will be very shallow, as it were. So you cannot be learning law without reading cases. And when we say reading cases, we mean you reading the full judgment, not just reading head notes all the time. So let us keep that in mind. So we come to the question, is jurisprudence a science? Is jurisprudence a science? Is jurisprudence a science? Well, to some extent, we notice that jurisprudence shares features with social sciences. So social science, about systematic description, theory building. So, some of the things like we encounter in economics, maybe sociology, political science, we can see some similarities with jurisprudence. But the point needs to be noted that jurisprudence is not an exact science. It's not an exact science because an exact science, the scientific method is said that if you have used it to establish a particular principle or theory, that experiment should be repeatable. It should be possible for it to be repeated, and the same outcome should be seen. But jurisprudence is not that kind of exact science because universal predictive laws are very scarce. And even when it comes to legal transplant, we have to be careful because laws which have worked in jurisdiction A may not work in jurisdiction B. Country A may not work in country B. So we need to appreciate that. Again, experimentation is limited. So many jurisprudential questions are normative. Normative in the sense that they are odd questions and you cannot test or verify them by standard scientific methods. And that is why Karl Popper's skepticism about providing definition of anything and also verification provide a useful reminder to us to avoid category mistakes. In other words, trying to pigeonhole. We have to avoid pigeonholing. Trying to subsume knowledge into a particular or distinct field. So borrowing scientific vocabulary does not make jurisprudence a science. If, in some respects, we tend to use language which is sometimes used in the sciences, that per se should not make jurisprudence an exact science. So the more accurate kinship or the more accurate family jurisprudence belong to its philosophy. Because jurisprudence, like philosophy, is a disciplined reflection on reasons and concepts connected to concrete legal practice. So, when it comes to a constitution, Article 125, that final judicial power is vested in the judiciary. So you want to ask yourself, why is it so? Why is it that apart from the judiciary, no other entity or body is given final judicial power? So much so that in law of contract, if you remember what you call the ivory cross, the case of Scott and Ivory, which provided, among other things, that in making a contract, the parties may provide their own internal dispute resolution mechanism and say that that should be exhausted before recourse may be had to the law court. And the court said that, yes, there's nothing wrong in having such a provision, so long as you have not ousted, that is, you have not stated categorically that the courts cannot intervene. So long as you haven't done that, then there is nothing wrong in providing that if internal mechanism for resolution is there, it should be exhausted first. Remember the case of Sleafy and Tete. The same point was made by our Supreme Court. But if you decide to say that only a particular method of resolving disputes outside the court is the one to be used, and under no circumstance shall the law court, for example, come into the matter, then that is wrong, because you'll be undermining the constitutional position that final judicial power is vested in the judiciary. You can delay when the courts can intervene, but you cannot perpetually bar the court from intervening in any dispute. So let's look at a few matters about vocabulary and style. How jurisprudence speaks. So we've noted that jurisprudence makes a borrowing from various fields of study. So jurisprudence borrows terms from law, philosophy, sociology, and also develops technical vocabulary. So I've mentioned Hoffel's analysis of right, and he will do his scheme and say that sometimes when a person says, I have a right, there is a corresponding duty. So you talk about what they call the claim right. I have a right to maybe education. You say that's a claim right, okay. And there's a corresponding duty. It's somebody's duty to do certain things or not do certain things so that that right can be enjoyed. Or liberty. If someone says that he has a liberty, if he has a liberty over something, then what it means is that no one can do or exercise a power in respect of that which he has a liberty. Or if someone has a power over something, then that person may enjoy immunity from that over which he has a power, as the case may be. So these are some of the technical vocabularies we are talking about. But Professor Hart provides an important warning. And what is that warning? That many what is S questions, that is what is something questions, are ambiguous between definition, origin, function, purpose. And for that matter, we need to carefully rephrase such what is type of questions in order to avoid these confusions. So later on, when we are looking at his work, the concept of law, some of these things will make much more sense to you, so don't worry now. Now, again, we have a linguistic term. Words may do emotive as well as descriptive work, as we have seen earlier on. And we have to appreciate that facts are not identical with statements of facts. So facts, what something is or what some things are. Facts are different from you making a statement of what the things are. So that is the point we are trying to make. And in that respect, Dannett and Jackson also remind us of what they call the legal register, how legal language can misfire across shared levels. For example, lawyer-client. Lawyer-client, we have an assignment of information. The way the lawyer understands things are different from the client. Again, they also remind us of how nonverbal signs like forms, formats, rituals carry normative force. So, for example, when it comes to seal, right? You remember law of contract, contract under seal or contract by deed, where a seal is put on a document. It's just a format, but it carries significant force. So, can we draw the boundaries of jurisprudence then? Can we delineate and say that it is this area which constitutes the territory of jurisprudence and other areas do not form part of the territory of jurisprudence? So, Allen, drawing upon his ideas, which we've mentioned earlier in the day, will make the point that jurisprudence must police its limits to remain useful. So not every insight from neuroscience or economics is jurisprudentially salient or relevant, though motivational psychology may bear on responsibility. Yes, so much as interdisciplinary approach is needed in doing some aspects of jurisprudence, we are also reminded that we have to be selective in terms of which aspect of other knowledge fields we use as a framework for trying to explore the meaning, the underpinnings, and evolution of the law and legal concepts. So we have, for example, law and economics, okay? We have scholars who will try and use economic thinking as a framework for questioning whether legal rules or institutions are worthwhile. Economics is about efficiency, okay? Efficiency, minimization of cost. So, legal institutions, from economic point of view, are they legally efficient? So, regarding the necessity of drawing the boundaries of jurisprudence, we may profit from Chesterton's aphorism that the frame matters. And earlier when I explained the frame, like the frame of a picture, because it captures why limiting subject matter is a precondition of fruitful theory. If you are going to build an explanation of anything, you need to draw the scope so that you have a control over the territory you are dealing with or talking about. Boundaries also help distinguish jurisprudence from other related enterprises like legal history. Yes, legal history, of course, we have a historical jurisprudence, but legal history is not equal to jurisprudence, despite the fact that in talking about historical jurisprudence, some aspect of legal history may be relevant. And also, doctrinal exposition alone is not equal to jurisprudence. So if you take something like the duty of care and you are explaining it doctrinally, that is not jurisprudence necessarily. In the same vein, policy science is not necessarily jurisprudence. So, classification, is it a useful map or false comfort? In trying to classify, is there any value in it or is unnecessary exercise, then deceiving ourselves? So we have various scholars who have attempted to provide some kind of classification. And this classification attempts to sort or categorize the theories. So you take Salmon, for example, he will talk about analytical jurisprudence or exposition. Historical jurisprudence and ethical jurisprudence. Again, Stone will also talk about analytical jurisprudence, sociological, and then a theory of justice. Keating will also talk about, you use content, time, number of systems, and then foundational discipline. And these are supposed to be the heuristics, not taxonomies of nature. So not the necessarily, cast in stone terminology, as it were. So you can classify jurisprudence in various ways. But the warning or the caveat is that the classification cannot be very neat because we have overlapping. There are some jurists or some scholars in this area. It's difficult to pigeonhole or to put in a particular category. If you take somebody like Professor Longfuller, sometimes you cannot place him strictly in natural law. You can also not place him strictly in legal positivism. Radbrack, the same thing. Or if you take Joachim, Ronald Joachim, you cannot say strictly that he's a legal positivist. You can also not say that he's a natural lawyer, a natural law scholar. So they resist neat pigeonholes, as it were. So therefore, we have to treat the various schools of jurisprudence as convenient arrangements for orientation, not as hard compartments. So they are not watertight, okay, categories. They are just convenient arrangement for providing some direction regarding the learning and discussion. Now, a lot of students, if they had their own way, would say that to hell with the subject jurisprudence, I don't want to do anything with it. But is that really the case? Does jurisprudence matter for legal practice? So I propose to you that yes, jurisprudence matter for legal practice, and it's not just a requirement you have to meet in order to be given your LLB degree. So why jurisprudence matters for legal practice? It supplies a grammar for hard cases. There are cases which are so novel in the sense that there is no existing precedent, and in terms of even statutory law too, there is no clear provision or explicit provision which speaks to that. That notwithstanding, once there is a case, the case must be resolved. You cannot ignore cases for the reason that there is no precedent which speaks to it. Every case must be resolved and remedies should be provided. And this is where jurisprudence becomes handy, because it provides conceptual analysis to avoid equivocation, to avoid making categorical or absolute assertions or claims. Normative reasoning to justify outcomes. So certain outcomes may be given and you try to justify it, why that outcome is the way it should be. And then empirical sense to anticipate institutional behavior. So sometimes you read even judgments and the court may come to a particular conclusion, and having done that, they may also raise the concern that the state of the law is not what it should be, that there's a need for reform or certain things should be done, and the judges may highlight that. Again, jurisprudence clarifies the validity morality distinction with the separability thesis, if you remember, while keeping aside of their interactions in doctrines. So there are a lot of doctrines where natural law and legal positivism is and ought questions. They have to sit at the same table. They have to impact on one another. For example, if we are talking about rule of law, we are talking about rule of law, there are issues of validity, there are also issues of morality. We are talking about proportionality. Proportionality, for example, when it comes to the law of self-defense and other areas of the law, you see the convergence of issues of validity and morality. Again, jurisprudence disciplines the use of language in advocacy and judging. So when lawyers are pleading cases, are making arguments, they are careful because language have serious implications in terms of their meaning in various contexts. So when you are dealing with a particular area of the law, you are careful about what to say and what not to say. I remember some of the students, you read their scripts in some of the law school exams and faculties. Maybe there's a question, for example, about remedies for breach of contract. And somebody will be talking about some aspect of criminal law and punishment. So certainly you are off. So in the same vein, lawyers too are very careful when they are using language in advocacy. And that discipline or that awareness is actually made possible by the subject we call jurisprudence. Again, judges are also very careful in the language they use in writing judgments and rulings because of how slippery language could be in the law. And this discipline is all brought about by jurisprudence. And it reduces error, a bond of ambiguity or emotive slippage, as the case may be. Again, it encourages methodological self-awareness, knowing whether one is arguing conceptually, normatively, or empirically, and when to integrate the three. It's very important. There are some cases that you have, depending upon what the state of the law is and what you are trying to invite the court to do, you may need to not only be arguing conceptually, you may also need to argue empirically. For example, if you want maybe the law to be developed to include a particular term, you might have had some research work done, some findings and all that, and you put them before the court as part of your materials to drive home the point you are trying to make. So all these are some of the importance or the utility of jurisprudence for law practice and adjudication. So at the end of the day, we could say that for our working definition, jurisprudence is the disciplined three-mode inquiry: conceptual, normative, and empirical, into what law is, how it justifies authority and obligation, and how its language and institution actually operate over time. So we will end our introductory lecture here. But let me say that for our next topic, which is supposed to be the natural law school, I have done pre-lecture recordings, and I'm going to push all of them to you for you to play and also read material I'll send you. Now, when I come to next class, I will just use 20 minutes to ask you questions for you to speak to me, and I'll move on to a new topic so that I will assume that those topics have been taught already, and then we can cover so many grounds. So we will meet in the company law classroom in a few minutes with another link.